Yes.
Here, I suppose.
Yeah.
Yeah.
Yes.
So first and foremost, welcome to all of you. The esteemed panelists of today's webinar, honorable judges who have joined, senior advocates, lawyers, mediators, my dear students, friends, welcome to all of you. It's a real honor to welcome all of you today to this webinar on the topic ease of dispute resolution in the context of ease of doing business. Is mediation the way forward? Before we proceed further, let us observe a minute's silence in memory of all those who have lost their lives to this unfortunate pandemic, particularly our COVID warriors who have sacrificed their lives in the service of others.
Yes.
Thank you very much. Our today's topic is of great relevance, not only as a general proposition, but more particularly in the present context where businesses are going through a period of great distress and loss. We have a very learned panel with us, and I'm very grateful to all our panelists today, especially to Dr. Suresh Prabhu, who has got a hectic schedule and who may not be able to be with us till the end of the webinar, for taking time off their schedules and accepting our invitation to speak on this topic. I'm sure all of you will be very eager to listen to them. We have planned this webinar not as a webinar per se, but more as an informal, a sort of a fireside chat. So though we have framed questions for each of the panelists, I would request all the panelists to pitch in and share their thoughts on any of the questions that may be addressed to the other panelists also. Now, after the discussion with the panelists is over, the floor will be thrown open to the audience to ask questions. I'm privileged to have with me Pushya Sitaraman, senior advocate, who is my co-moderator. Pushya and I will now introduce our panelists. We are very privileged to have with us Dr. Suresh Prabhu, a former union minister and the Prime Minister's Sherpa to the G7 and G20 summits. Dr. Prabhu comes with an incredible amount of political and administrative experience. He has held various cabinet portfolios, including Union Minister for Commerce and Industry, Union Minister for Civil Aviation, for Railways, for Power, for Environment and Forests with the Government of India. He's an ace administrator with great panache, known for his out-of-box thinking, and he has scripted various reforms and organizational transformations wherever he has held his post. He is now the Prime Minister Sherpa to G7 and G20 summits and has been the official emissary of the PM to G7 and G20 forums. And he has been involved in shaping the official agenda for the Government of India on key issues in these summits. He has been engaging with global leaders and thinkers and leading delegations across the globe. He is currently a member of the Rajya Sabha from Andhra Pradesh. He has been a member of Parliament in the 11th, 12th, 13th, and 14th Lok Sabha, and has taken a host of initiatives to ensure constituency development, legislative reforms, and opinion building. He's an entrepreneur and banker par excellence, and as a chairman of Saraswat Cooperative Bank Limited, he has been the youngest ever chairman of the largest cooperative bank. He started his professional career as a chartered accountant, having established his own chartered accountancy firm before joining politics in 1996. His life has been devoted to worthy social causes and he's connected with over 150 social and cultural organizations. He has been conferred an honorary doctorate by the IIFRI and is pursuing PhD in climate change issues in relation to energy and environment from Frey University, Berlin, and a PhD in state public finance from Mumbai University, Mumbai. Pushya will now introduce Justice Julian Joseph.
Justice Julian Joseph is not a stranger to mediators in India. He started his legal career in 1979, and he also served as Additional Advocate General of Kerala. In 1996, when he was just 42 years old, he was designated as a senior advocate. He was elevated to the bench of the Kerala High Court in 2000 and served as a judge there till he became the Chief Justice of the High Court in 2010. In 2013, Joseph was elected to the Supreme Court. He is retired in 2018 after a very productive career where he has crafted more than 1,000 judgments, which a very few judges have done in the history of the Supreme Court. He is a trained mediator and empaneled as a mediator with the Singapore International Mediation Center, apart from being empaneled as an arbitrator with the Singapore International Arbitrator Center and the Delhi International Arbitration Center. He is an inspiration to all mediators. Welcome, sir.
Thank you, Pushya. We are also very privileged to have with us Mr. Sriram Panchu. Yes,
you
sir.
will introduce Mr. Sriram Panchu.
Yes, I'm doing that. Thank you, Pushya. Mr. Sriram Panchu is a senior advocate of 44 years standing at the bar. I'm sure there's not a single mediator in India who has not heard his name. And even if you're not a mediator, you would have definitely heard his name in different contexts. He's also in the forefront, he has been in the forefront of the mediation movement in India. He's an internationally recognized mediator. He's an alumnus of the Government Law College, Bombay. He commenced his practice in 1976 at the Madras High Court and was designated as a senior advocate in 1996. His field of law practice is constitutional and commercial law. He has appeared pro bono in several significant public causes before the High Courts and the Supreme Court. For almost 30 years, he has been in the forefront of the mediation movement in India. In 2005, he set up India's first court annex mediation center at the Madras High Court, and he has assisted the Supreme Court and other high courts to do so in various other states. He has trained over 1,000 mediators. His books on mediation, Settle for More, and Mediation Law and Practice, published in 2007 and 2011 and 2015 respectively, and Commercial Mediation Monograph 2019, virtual Bibles for mediators. He has mediated a large number of complex and high-value commercial disputes in India and abroad. He has also mediated significant family disputes, including inheritance and family business disputes. He has been appointed by the Supreme Court to mediate significant public disputes. This includes a border dispute between the states of Assam and Nagaland and a dispute within the Parsi community in Bombay over a ban on priests. In December 2018, the Bar Association of India conferred on him its Lawyer of India Day Award of Honor and Distinction. In March 2019, he was appointed on a 3-member panel to mediate the Ayodhya Ram Janmabhoomi Babri Masjid dispute. Mr. Panchu is a member of the National Legal Services Authority of India, NALSA, and president of the National Association Mediators India. He is a director of the International Mediation Institute and is on the panel of senior mediators of national and international institutions. He heads the mediation chambers, which offers a range of mediation services. He serves on the committees of several public, charitable, and social organizations. Over to you, Pushya, for introducing Professor Joel Lee.
So Joel Lee is a professor at the Faculty of Law, National University of Singapore. He has co-pioneered the teaching of negotiation and mediation in the Singapore universities and has played a significant role in furthering the development of mediation in Singapore, not just in education, but also in practice. A graduate of the Victoria University of Wellington and Harvard Law Schools, Joel is a partner with CMP Cambridge, USA, and a principal mediator with the Singapore Mediation Center. Mr. Joel Lee was a member of the International Mediation Institute's Independent Standing Commission, Intercultural Task Force, and was also a key member of the Ministry of Law's Working Group on International Commercial Mediation. Joel is presently the founding chair of the board of the Singapore International Mediation Institute. He is also a certified trainer of neuro-linguistics programming. He has taught overseas at the University of Copenhagen in Denmark, the University of Law, Economics and Science of Marseille, Aix-en-Provence, France, and Anglia Law School, UK. And he's the co-editor and co-author of the book, An Asian Perspective on Mediation, and the Singapore Mediation Handbook, and the general editor of the Asian Journal on Mediation. In 2011, Joel was awarded the Outstanding Educator Award, which is the National University of Singapore's highest teaching award. Welcome, Mr. Joel.
Thank you, Pushya.
Yes. Will you introduce Brian Spears?
Yes. Thank you. It's my honor to introduce Mr. Brian Spears, who has been elected as the President of the Commonwealth Lawyers Association in 2019. In 2010 to 2011, Brian served as President of the Law Society of Northern Ireland. He is now the Treasurer of the Law Society of Northern Ireland. He has been a pioneer of mediation in Northern Ireland and devised and teaches the ADR and mediation training program for solicitors, barristers, and judges run by the Institute of Professional Legal Studies at Queen's University, Belfast. He is the chair of the Law Society of Northern Ireland Mediation Service. Brian has been regularly interviewed on various print and broadcast media about mediation and legal affairs generally, and has written extensively about mediation, particularly in the Journal of the Law Society of Northern Ireland. He was a UK-nominated mediation expert to the CCBE bar associations across Europe for the publication of a guide to mediation for lawyers. Brian is an experienced solicitor, mediator of disputes, which have involved private individuals, corporations, government departments throughout Northern Ireland, in the Republic of Ireland, and in Great Britain. Welcome, Brian.
It is my pleasure to introduce Mr. Rakesh Khanna, Senior Advocate practicing in the Supreme Court of India and various high courts. Mr. Khanna is the former President of the Supreme Court Bar Association. He has also held office of Additional Solicitor General of India at the Supreme Court. In addition, he is presently serving as a member of the Supreme Court Legal Aid Committee. Mr. Khanna is a trained mediator and is actively involved with the activities of Nivaran, the Supreme Court mediators. Nivaran has been conducting a lecture series since April 2020, wherein mediators from jurisdictions across the globe have been sharing their learning, knowledge, and experience with not only Supreme Court mediators, but also mediators pan-India and Commonwealth countries. I have benefited a lot from the Nivaran lectures, sir. Nivaran has till date conducted 3 international seminars and 8 lectures, couple of interactive webinars, summer school on mediation, etc. during this pandemic. Welcome to the panel, sir. Jawad?
Yeah. So our next guest of honor is Rahim Shamji. Rahim is the CEO and founder of ADR ODR International Limited, based in UK, which is a thought leader in alternate dispute resolution and online dispute resolution. ADR ODR International is the largest and fastest growing dispute resolution provider in the world, with a presence in almost more than 36 countries, if I'm not wrong, Rahim. Rahim has been working in India since 2012 and is a very progressive thought leader in dispute resolution. Rahim strongly feels that the future is to be the digital dispute resolution specialist. Rahim is a peacemaker. He always says that mediation is nothing but peacemaking, and he is a political junkie. So welcome, Rahim. Thank you for joining us. Over to you, Pushya.
And last but not least, the only woman on the panel, Zoe Guanapolu. She's a practicing lawyer and mediator and she holds an LLM and PhD on European and Economic Law. Zoe is a felicitator at the OECD panel and a member of the Hellenic Ombudsman for Banking Investment Services panel. She has served as the Deputy President of Mediators Accreditation Committee at the Ministry of Justice, Greece, and as a member of the Working Committee on the implementation of the ADR Consumer Disputes Directive, and also as representative of the Hellenic Ministry of Justice. Zoe is the founding member and director at the European Institute for Conflict Resolution, which is an official alternative dispute resolution entity notified to the European Commission and registered to the European ODR platform. Welcome to the panel, Zoe.
Thank you, Pushya. Welcome, Zoe. I will be failing in my duty if I don't introduce my co-moderator, Pushya Sitaraman. Pushya is a
Already done that, George.
Pushya is a designated senior advocate of the Madras High Court. She has been practicing as an advocate for over 30 years, specializing largely in the field of taxation and corporate laws. She underwent mediation training with Geeta Ravindra of the Virginia Supreme Court, further with ADR Group of UK, and recently with ODR International too. She has been actively mediating disputes offered by the Madras High Court with the Tamil Nadu Mediation and Conciliation Center, and she, for almost 10 years now, she is one of the founder trustees of the Foundation for Comprehensive Dispute Resolution based in Chennai. Thank you very much, Pushya, for joining me today in hosting this webinar. Welcome. So I think we'll straight away jump into the questions because Mr. Suresh Prabhu will have to leave a little early. He may not be able to be with us throughout the webinar because something urgent has come up for him. So I will start with a question to Mr. Suresh Prabhu, and we will be very happy if he can enlighten us with his insights on this. Sir, the question that I would like to ask you is this. Considering that India was one of the first signatories to the Singapore Convention, which was actually seen as a very progressive step, do you think the ratification of the Singapore Convention and possibly an earlier enactment of a statute for mediation would be seen as a positive step in improving the ease of doing business in India? Perhaps it may result in increased inflows of foreign direct investment. And also, do you think that the lack of follow-up by ratification and enactment of a law is affecting the foreign investors' perception of India as a viable investment destination?
So, thank you very much, and I congratulate Jawad and his colleagues for bringing in together such a fantastic luminaries on some common screen. I really wish to congratulate you, and I think knowing your attitude, Jawad, as a real conciliatory attitude, always trying to talk to people and try to forget resolving dispute, but not to allow the dispute to arise to begin with. I am sure you are the right person to anchor such a program. So congratulations to you and your colleagues for doing such a wonderful job. I'm really impressed by my co-panelist, and therefore I decided to go a little early because I cannot be in such a distinguished company. They are all such accomplished and such great people. I don't deserve to be there. I just wanted to take your permission to go a little early for a simple reason that I am trying to work on addressing the challenges of so many COVID patients. In fact, right now I have to attend some other meeting, and that's the only reason I wanted to excuse myself. I'm sorry about it. Coming to this very important issue of dispute resolution, mediation, and these are very pertinent and very relevant questions you asked me about Singapore Convention. While you go to that, while you're absolutely right that ratification is something which is still not being made, but you will appreciate the fact that many of the statutes which have been passed by the parliament lately, there is already an inherent provision for dealing with dispute resolution through mediation. So this is something very important. Even our insolvency law provides for it. So many other laws actually make a provision for it. And as you know, whether we like it or not, when you enter any commercial transaction, there is bound to be some dispute. If there was no dispute, probably the lawyers will not put that clause into the agreement to begin with, that how do you redress a dispute. So we presume that dispute is bound to arise. And you mentioned I was a commerce minister. When I was commerce minister, I was just thinking to myself, probably where this term trade-off must have emerged. Where was it born? The term trade-off. Some people will call it a trade-off. So obviously, any business transaction could result into some dispute or the other. So we must have a mechanism to deal with this. And Dr. Advocate Jawad is absolutely right that one of the reasons why, we should take a lead into such a measure is for making India a destination for more investment. At the same time, making business in India should be a pleasurable experience. I was a minister in charge of ease of doing business. That was my responsibility. I used to always say that now we should move from ease of doing business to pleasure of doing business, pleasure of doing business. So ease of doing business is fine. People must enjoy doing the business. And that could happen when we don't have to go to the courts, we don't have to follow the legal process. But if there is a dispute, which is bound to happen, we can resolve it. In fact, dispute is a part of inherent human nature, because all the time we call it a twin personality that we already have in each other person. The good and the bad keep fighting each other. So obviously, something or the other, my nature, my tendencies, my approach is going to result into some sort of a dispute with a counterparty. And therefore, we must have a mechanism to deal with it outside the courtrooms and try to resolve it. So we should try to work on that. I think we must take it forward. The insolvency board actually, I think it was less than 20% of the cases are going through this mechanism. Otherwise, they are going to insolvency. It is really not necessary that we have to wind up a business only because you cannot resolve a dispute. I think it's all possible to do it. I think we should work on it. I fully agree with you that arbitration, resolution of disputes through such processes will definitely happen. In fact, incidentally, Arbitration Act has been passed by the Parliament. Recently, we introduced some amendments also to it, as you know, and those amendments are also necessitated by some of the judicial pronouncements. So I think this is a good way forward. I fully agree with you that we need to move on by ratification with some of the international treaties, which we are already a signatory. So that follows that we have to actually, there's a logical conclusion that we must do that. But I fully appreciate this is the only way forward. There are millions of cases pending in the courts, and it should not be another one that we should be standing in the queue. And as we said, that justice delayed is justice denied. So that is something which has to be kept in mind. So therefore, this is the only way we can do justice to our own self, by going in for this alternate dispute resolution mechanism than following the legal process of going to the court of law.
Thank you very much, sir. Before we let you go, I think Pushya may have some questions for you.
Okay. Please.
Pushya, can you please go ahead?
Yes. As you're aware, sir, India was 134 in the ease of doing business index in 2014. We have climbed up to 63 in 2020. There are two important sub-indices that we are concerned with in our topic for discussion today. That is enforcing contracts and resolving insolvency. So what are the steps that we need to take to improve these two areas? As we all know the ground realities today, the time taken and so on. So what steps should we take, both on the part of the government, the judicial system and the public, to improve India's score on these two sub-indices? That is, how the ease of enforcing contracts and of resolving insolvency.
So I don't want to create another dispute by replying it wrongly. So Jawad, can you please tell me? I could not. I think there was a lot of. I could not hear it properly.
Yes.
Can you just briefly?
No. Pushya's question was: India was ranked as 134 in the ease of doing business index, which was prepared by the World Bank in 2014. Yeah. Now in 2019-20, it has come up to 63 ranks, which is a vast improvement actually. For a very short period. So her question is that now two of the very important sub-indices there, because there are 10 sub-indices that World Bank has prepared for the ease of doing business to calculate to do the ranking on that index. Out of that, enforcing contracts is one, and resolving insolvency is the other. You have already referred to the Insolvency and Bankruptcy Act, because one of the primary factors, I think, in taking India forward on the indexes, the Insolvency and Bankruptcy Act. So the question is, what are the steps from the perspective, because you have been in administration for a very long time. So from that perspective, what do you think India should do to further improve the score on these sub-indices? Because we are still ranked as easy, not very easy.
No, I agree with you. In fact, let me explain to you. The ease of doing business, as you correctly pointed out, is an exercise which is carried out by the World Bank across the world. There are fixed parameters, quite a few parameters, on which they judge it. And as you correctly pointed out, 2 or 3 parameters, one of the sanctity of contract, enforcement of contract, dispute resolution is one group of that. So what we are doing was, we really studied each and every aspect of it. And in that ministry that I was in charge, Commerce and Industry, the secretary DIPP at that time is now called a DPIIT, was entrusted with the responsibility of talking to the states, because much of it happens in the states. For example, construction contract is one such parameter. And a construction contract is something which is a local government responsibility, not even the state government, but local government like the municipal corporation or the state development authority, they deal with that. So we were actually working on each and every aspect of that and working with all the people, all the stakeholders to find out how that can be addressed. So this dispute resolution, you are absolutely right. This is one of the very important components on which we are working. And one of the reasons why some of the laws, now you find that there is a provision which is made into that dispute resolution is thanks to this exercise that was carried out. But you're absolutely right. We have to go a long way in improving that. But I personally feel that while we do this, then we started working on states. We started doing ranking of states the same way that the World Bank does ranking for the country. We in the ministry, we started the exercise of ranking the states according to ease of doing business. And in fact, Andhra Pradesh had stood first when I released those rankings when I was a minister. It's a different matter that I also happen to be right now the member of parliament for Andhra Pradesh. So that's a matter of pride rather than the reason why we became like that. So I feel that it is absolutely right. We have to work on quite a few of these parameters. And one of the key components is dispute redressal mechanism. And not just for improving ease of doing business, ranking, but for actually helping the entrepreneurs, the business people, to solve their problems on their own. And it's a cost effective, time effective, and also helping the people rather than when it gets prolonged, the relationship get more strength, and the asset, underlying asset, if it is, the asset is under dispute, the valuation goes down. So nobody benefits actually. So I think you are absolutely right. We have to work on many of these areas. And I think one of the days I would like to join with you to take these ideas forward. Thank you very much.
Thank you very much for joining us, sir. We wouldn't like to hold you back anymore because we understand that you have
I'm really sorry about it.
To discharge.
And I seek particularly the permission of Justice Kurian because he is presiding over this program. So I take his permission. And I'm
Just
sure
pleasure listening to you, sir. You have definitely these are the testing times. Your presence is required other places also.
I'll be with all of you. I'll join with you. And I'm very happy to see such huge number of dignitaries from different parts of the world joining in. I welcome them on behalf of my country. I really look forward to working with all of you. Thank you very much. Congratulations.
Take care, sir. Stay safe. Yeah.
Thank you, sir. Thank you. Thank you very much for joining, sir. Thank you. Okay, now the next question we would like to ask Justice Julian Joseph. Sir, as Pushya already pointed out, you have been one of the most prolific judges of the Supreme Court of India. What are your views on, and now you are an arbitrator also with not only the Singapore Delhi International Arbitration Center, but also with the Singapore International Arbitration Center. So what are your views on litigation and arbitration as dispute resolution mechanisms from the perspective of ease of doing business? What are the shortfalls and the lacunae? And how do you think this is impacting businesses, starting from MSMEs to big corporates?
Yeah, thank you, Javed, for organizing this platform. And thank you, my dear co-panelists, and also the people who are participating in this wonderful webinar or fireside chatting, whatever you may call it, because all of us are very passionately interested in taking forward these dispute resolution mechanisms for the sake of amicable settlement of disputes. That has brought us all together, despite the times being testing. Yeah. See, arbitration and litigation are two known modes of dispute resolution. One. As far as litigation is concerned, that is the originally conceived and conservative mechanism also. And that litigation is only through a judicial or a quasi-judicial forum. So that's always adversarial, right? And whereas arbitration, it was conceived by the UN on three fundamental aspects. One, fair. Two, efficient. Three, amicable. On three parameters, if you analyze this UN resolutions, etc., we can discussions also. Three aspects have been given importance: fair, efficient, and amicable. Because it was sought to be a substitute for the normal method of adversarial litigation. Just come to a friendly platform. Let's have a fair, amicable, and efficient settlement of disputes. It was conceived well. But whether that dream of the international community in dispute resolution has been able to achieve its desired results is a big question. Because this itself has become what you call a highly litigative subject now, arbitration. So the international commercial dispute resolution mechanism of arbitration, domestic arbitration rules, etc., all have been undergoing changes because of the demands of times. The way the progressive definitions or interpretations on law or on the arbitration concept has been growing. So it has been successfully, even India also, from the 1948, it came to 1996, 1918, 1919. No, it is going on. But of course, we follow and we respect. In India, we respect the international conventions as well. That's why international commercial dispute resolution has been. But that has given what you call a confidence-bearing trust in the international community to what you call invest in India for doing business is a big question. Because people have been a little wary because of this litigative process in India. It takes a long time, no doubt about it. Unfortunately, India is what they call a legally literate state. Therefore, people don't take law in their hands, they go to court for every resolution. So much so, we are all, in a big mess as far as judicial process is concerned. It takes some time. Therefore, we are looking for alternate dispute resolution mechanisms and arbitration. In that process, arbitration also, I don't get involved. The reason is, it doesn't end there. We thought of fair, efficient, and amicable. But maybe it is fair, but where it is efficient and amicable is also a big question now. Because from my experience, I found that 95% of the arbitrations, the awards in arbitration, particularly when PSUs are involved, and also when international commercial disputes are involved, are being taken to the court for the next stage of a challenge. So what's the purpose of it? We thought of using this arbitration for reaching a finality by a fair, amicable, and efficient settlement. It's not reaching that. It is in that process, we have a feeling that both litigation and arbitration are not actually easing the business or investment. So we have to find a solution. That is why the mediation is now being thought of. So if you find all international commercial contracts or even domestic contracts also, we have started a new process. Even when, as Mr. Suresh Babu rightly said, see, you don't conceive all possible disputes when you enter into a contract, right? And as he later he said, no, it's all being vetted by lawyers. That sometimes they give some room for litigation source because they can see they can see far ahead a likelihood of a litigation. So they provide a clause. So that is why if you see the contract clauses in the event of a dispute. So it's not that if dispute should always be in the event of dispute. Now we have started a clause in that. Now, first of all, try to solve internally. Number one. Number two, if not possible, then go for an amicable settlement by mediation. If both these two fail, then only go for an arbitration. That is the difference. Therefore, both litigation and arbitration, according to me, are not that way helpful for ease of doing business. They are good, of course, but for Indian situation, it is very difficult because of litigative process and litigative mind and literacy rate, legal literacy rate of India, because the people are not prepared to suffer a defeat that way. They just don't give up. They just don't leave it. They fight it to the last. Therefore, to me, I believe both these two are not helping the ease of business. We need to find out solutions for that.
Thank you, sir. Thank you. That was quite insightful, because basically what you have said is today people are going for more of a hybrid sort of a mechanism where they provide for negotiation than mediation. And when both fail, that is the last resort is arbitration or litigation. So, Kushal,
can I come in
yes,
there?
sir, yes, sir. Yes, sir, please.
I just want to, pose something to Justice Joseph. So you talked about, arbitration and the fact that, where is the amicable aspect in arbitration? So the question I want to ask you is, we all know that there is, one of the essence of mediation is the fact that it brings forth amicable solutions. So we do advocate a combination of arbitration and mediation are made up in suitable circumstances in the appropriate cases. So would you like to share your thoughts on that? Because there you may achieve finality as well as you may achieve the amicability of the solution.
Yeah, thank you, Sriram, for that good intervention. Because, under the Indian legal regime, there is a section 30. We can go for the word used is, it is not, it's actually the duty of the arbitrator to encourage settlement. Though it is put in the double negative. Actually, the wording is very important, very interesting. It is not incompatible with an arbitration agreement for a tribunal to encourage settlement. If you have been simply put, it is always better to encourage settlement. What are this? Yeah. See, arbitration is intended, well, as I told you, for a fair, efficient, and amicable. Well, in that process, I've been experimenting with these two aspects. Where people are not, if people are able to agree on, say, out of the 5 claims, say if they are to agree on 3 claims, very good. Therefore, there is a finality to the 3 claims. So you can use this mediation in the arbitration process. It is actually the obligation or a duty cast on the arbitrator to engage settlement. Whereas, I've seen always arbitrators taking a very conservative stand that it is for the parties to suggest. Not out about it is for the parties to take initiative. But it's not incompatible for the tribunal to make a suggestion that this is the framework. This is actually your dispute. And on that, you don't require a legal interpretation or a final award. Because if you are able to agree on certain aspects of bit of a give and take or agree on certain aspects, because you are to continue your relationship and you are not going to end your relationship. You are to continue your business. You want to be in business also. Therefore, use this process of, to the extent you are able to agree on a few claims, please agree. And I'm quite sure in one of the arbitrations I found, when they were able to agree on 3, rest they were also able to agree on the 4th and 5th also. So therefore, Mr. Sriram, I agree with you. The tribunal should encourage this mediation process also in arbitration. Many of the arbitrations have been taken up to court under challenge because the tribunals have failed and advocates have not cooperated, and the parties have not thought of this possibility of an amicable settlement. It is fair, it is sufficient, but the amicability has not been explored to the possible extent.
Sir, may I be permitted to put a supplementary question? Sir, as an arbitrator, I heard you have been putting parties to mediation. What has been your experience, especially in commercial litigation, when you have referred the parties to mediation? How successful those mediations have been?
Yeah, Mr. Khanna, you yourself are a living example for that. I have appointed you as a sitting judge to resolve commercial disputes as well. People have a bad notion, even now in Supreme Court, that mediation is for matrimonial disputes or domestic disputes, no, for partition, etc. Very important and very intricate corporate disputes also can be referred to, because there's nothing. This actually parties agree on what the concept of their claim is, and to what extent they can have an amicable solution for, not only an amicable resolution, an amicable solution for the continuing relationship. So relationship is more important. Mr. Khanna has been a successful mediator in Supreme Court as a senior advocate, as a president of the Bar Association also. I used to engage him. There is also Mr. Sharma is also here. There are so many senior advocates. And even a dispute on an intellectual property claim on a patent, that was also settled in mediation. So my experience has been wonderful. That if you entrust it to lawyers who are trained mediators, it's very successful. They are able to tackle, and they will be very successful. So my experience has been wonderful. That mediation is a very effective tool in settling the commercial disputes as well. Particularly when it reaches the level of the Supreme Court, people are tired. First level, second level, and they want to get out of the court at the earliest.
Sir, do you think that we are ready for pre-litigation mediation, especially in commercial and government disputes, tender disputes?
Yeah, Mr. Khanna, pre-litigation mediation is a well-conceived idea. In fact, there is a question coming on that. Now that you have asked that question, probably I can club it that way also. It's a good idea, but it will succeed only on a couple of conditions, which I would like to tell you. One, let's be very clear that without the involvement of lawyers, no mediation is going to be successful, right? Because it is their professional field for assisting the clients. So the mindset of the client should change, that even in pre-mediation litigation also, there should be cooperation and collaboration of the advocates, and they should be professionally paid for assisting the mediation process in the pre-litigation stage also. That is the greatest block I have seen. Number one. Number two, in the pre-litigation mediation, now in the Indian scenario, it's actually a formality. Pardon me for using this phrase. See, in arbitration, you have a party autonomy. You are able to select your own arbitrator, looking at his competence, looking at his integrity, looking at his availability, etc. But as far as the pre-litigation mediation process in India is concerned, either in the all the mechanisms, it's being referred to a particular authority, and they may give you somebody. In Supreme Court also, I've seen, I never ever referred the parties to a sender. I want, as far as possible, not that I have not done everything, I have done, of course, but I have always tried to name a particular, I know who should be because I know your potential. So a particular type of dispute I'll give to one Mr. The toughest of people also I understand. So is a party should be given that autonomy to select a mediator. As far as possible, if they agree on a mediator, well, that's good. I can tell you my experience in arbitration. Parties agreed for mediation in the process of mediation. Only on a condition that you should be the mediator. I told them that in case the mediation fails, I won't be able to continue because you are going to confide so many confidential things to me. They said, no, there's nothing like that. We have faith in you. we have confidence in you. This will succeed. So if we will agree for mediation in arbitration, provided you yourself mediate. And I agreed. I took the risk and I agreed. It was settled also because I knew the parties are very competent. So therefore, pre-litigation mediation, one, we need to have the collaboration and cooperation of the lawyers. Two, the mindset of the litigants should change. And three, of course, the party should be given the liberty or autonomy to select the particular mediator.
We have been looking at countries that we have panelists from countries where both arbitration and mediation, especially mediation, has been very, very successful for many years now. So I would like to ask them, what are they doing to, in regard to ease of dispute resolution? What steps are their countries taking? Are there any examples that we can follow in India and adopt it to improve the dispute resolution ecosystem, to create more faith and trust that this system will work? If I can ask that question first to Mr. Joel Lee.
Sure. Good evening, everyone, or good afternoon, everyone, depending on where you're coming from. Thank you very much for that question. Thank you very much for inviting me to be on this august panel. I'm honored to be in the presence of people like Justice Julian Joseph and Mr. Sriram Panchu and everyone else. I can't name all of you, but honor is mine. Let me just do the typical lawyer thing first and hitch my answer, right? So I'm just going to add a caveat. All of us are legally trained, or many of us are legally trained. So let me just put a caveat. I'll share a little bit about what we do in Singapore. But I will be the first to admit Singapore is a very small country, and what we can do may not easily be done elsewhere, or may not apply to the context and cultural backgrounds of other countries. Okay, so I share from our experience of what we've done, but I don't presume to actually prescribe, because I acknowledge that can't be applied cross-contextually. It really does depend. So Singapore, as you know, has made quite a significant effort in promoting dispute resolution, not just of mediation, but of all kinds. So, for example, the establishment of Singapore International Commercial Court, Singapore International Arbitration Center, Singapore International Mediation, and so on and so forth. The attitude is basically saying that for every dispute, what is the appropriate form of dispute resolution? Right, so we don't assume it's litigation. In the old days, everything was litigation. We don't just assume it is going to be mediation. It might be, as Panchu has said, a sort of a med-up situation. Sometimes it could even be arbitration. It's what is appropriate, right? And what's important is that the court system, as well as the mediation system and arbitration system, work hand in hand to provide the appropriate service for the appropriate dispute. So that's kind of like the philosophy, and I don't speak on behalf of the judiciary, but that's sort of like the philosophy that I see Singapore is trying to offer. Yeah, and that's why we, for example, will promote the Hague Convention on Enforcement of Court Judgments, and for example, the New York Convention, and of course the Singapore Convention on Mediation, because that becomes very critical that our judgments or awards or mediated settlements are recognized and enforced everywhere else, right? And that will take time. I understand the Singapore Mediation Convention hasn't been ratified, across the board yet. It will come, right? So that's one thing that we've done, and it's still a bit early days to see whether that's going to be totally successful, but that's certainly one thing that can be done. The other thing I want to address, which is something that Justice Julian Joseph had said, which is sometimes it is actually in the hands of the parties, or even in the hands of the counsel, the advocates, the lawyers, right? Mediation might actually be the best option or the more appropriate option at any point in time. My point of view is that actually most disputes should at least try mediation first, because you don't know what will get resolved, right? And then of course you can then have the option to go into arbitration and litigation. But a lot of it has to depend on how we educate either the parties or the lawyers involved, because a lot of the time the lawyers are the gateway, right? So in Singapore, for example, we teach mediation advocacy in law school. We teach it at the bar course. And the whole idea is to not make them experts. That's not the idea. But the idea is to say, hey, hang on a moment. You need to actually be able to think about, what is the appropriate form of dispute resolution? It could be mediation, right? Because it is in your client's best interest. And that's sort of one of the key things that we want to sort of ingrain in them. Of course, there are other things we can say, that the court systems have cost considerations, and they sort of promote, mediation in this one way or the other. There are forms that would fill in the presumptions and so on. I don't want to go into all of that because I don't want to eat into the time of Zoe and Brian as well. But those are just two things I'd like to share that Singapore has done. And there's more that can be said, but for the moment, let's just, I'll leave it at that. I'll shut up now. Okay. Sorry if I've taken too much time.
So can I ask Zoe to tell us how things are done in the EU? What steps have your country and other countries in the EU been doing in regard to ease of doing dispute resolution?
Thank you very much. I would like, first of all, to thank KD Lex Chambers and Nivaran Mediators of Supreme Court and ADR ODR International for the invitation. I feel extremely honored to be amongst so many distinguished professionals. I would like to share the experience from Greece, I would say, because I'm based in Greece. It's a very small country in Europe. And so far, we had one of the slowest judicial systems in EU. As you might know, we've been through a very difficult economic financial decade, and we had to do significant reforms in order to have investments again. So thank God there was a political will. And regarding the national commercial disputes, we have now a mandatory pre-stage of mediation for the disputes above 30,000 euros. So this is something that helps a lot in easing the judicial system. And regarding the international disputes, and I mean the disputes from between the state and the investments, we are a member of International Center for Settlement of Investment Disputes at the World Bank. And Greece has a panel of arbitrators and facilitators who actually provide a transparent, reliable, and predictable legal framework for investor investment protection, because this is the big challenge in Greece as well. So actually what we are trying to do in Greece is to, with this membership, to enhance naturally investor confidence, and we need investors in Greece, and promote incoming investment. And therefore, being a member of ICSID and, of course, having signed the New York Convention for the recognition, for the enforcement of arbitration award, play a significant role. And this is the way to attract foreign investors. And it's not only Greece, it's most of the member states in the EU have signed and are members of ICSID, and because there is no country, there is no member state that has signed the mediation convention, unfortunately. And we are waiting to see if this will be signed, if the mediation convention, the Singapore Convention will be signed as a block, I mean, all the member states of the EU, or the states will sign it separately. So I won't keep it long. I would say that this involvement with international organizations help us attract investments and create this transparent and reliable legal framework.
Mr. Brian Spears. How do things work in Ireland, Great Britain, and more particularly in Northern Ireland?
Thank you, and I echo my panelists' appreciation for the invitation and for the pleasure of the company of such a distinguished group of people, some of whom I have met before. And can I say that the Supreme Court of India mediators have really blazed a trail in the last year in promoting mediation and in arranging events like this and others where senior people from their jurisdiction and others participate in these interesting discussions. The question is widely framed in terms of a general enhancement of investment and trust in the system of resolving disputes. And I do agree with Joel and the philosophy from Singapore that what we need is a coherent system where the judges can recognize that mediation might help and pause or delay proceedings or extend time to facilitate mediation, that mediators need to be well and appropriately trained and effective in terms of their impact to assist the parties to resolve a dispute. And there have been initiatives from my perspective as president of the Commonwealth Lawyers Association that I see in some jurisdictions where there is legislation passed to mandate mediation in some cases. So Zoe has referred to smaller value cases, and in Northern Ireland we too are about to introduce mandatory mediation in smaller value cases. Now, some people might think that that is a contradiction in terms to have mediation, a voluntary process where the parties wish to resolve their dispute and are assisted by a neutral party. But I think we must get over our squeamishness about putting people into mediation and feeling that somehow that is against some holy writ of philosophy that mediation cannot be mandated. I think also that we need to recognize that for many litigants, for many clients, going to court is not a brilliant experience. It is slow, it is costly, and its range of decision-making options for the court can be narrow, whereas mediation can expand the resolution opportunities and the canvas for disputes. And any of the panel, many of them are mediators, and many listening are mediators, will know that disputes that can arise, that can seem intractable when placed with a mediator suitably skilled and trained can be resolved, and that the resolutions can be better than those that necessarily a court must impose. In the UK, there are costs sanctions for people who unreasonably continue with litigation or insist upon litigation. There are court rules that say parties must exhaust their resolution alternatives before accessing the court. And perhaps something can be said later about court rules saying you must not take up court time when you could have made efforts to resolve the dispute before accessing the court. And there have been many examples in the UK of adverse cost orders that even though a party notionally wins the case, the court will not award them costs because they have failed to avail of the opportunity to mediate. So I simply in this short intervention say that we perhaps need to think again about our squeamishness about mandating mediation in many jurisdictions. And you could look south in my jurisdiction to the Republic of Ireland, which has a Mediation Act, and which is a very well drafted and well considered piece of legislation in which mediators must be trained. They must disclose their training and their experience, and they must advise the parties of the alternatives and of the nature of the process. And we need to agree on what mediation is. Is it a facilitated process, or is it something that is a mixture of mediation and evaluation? And if we are going down the path of mediation and arbitration combined, the parties really need to have that explained to them so that they can consent to the process in which they're invited to participate. But for now, those are my reflections on this question. Back to you, Jawad.
Thank you.
Thank you. Thank you, Brian. Thank you, Pushya. Now, before I proceed to the next question, I would...
if you permit, can I make small comment here?
Yes, yes.
There was, you see, I'm thankful to three of my panelists for referring their experiences from their countries. But let me say, you see, insofar as some of the other countries like USA has introduced the ADR and especially mediation in USA in cases in 1986, when they introduced in the bankruptcy courts of Southern District of California by establishing mediation programs. And later on, USA, the first case they tried under the Bankruptcy Act was Gary Hound Lines Inc. case, in which they tried to resolve thousands of claims which were brought because of the personal injury and property damages claims by the company in connection with the traffic accidents involving Gary Hound vehicles. That was the first case in America where in bankruptcy case, they adopted the mediation and ADR process. And in that case, they adopted three steps. First step they said was the creditor had to complete the claim from the lost wages, medical bills, and other damages. In second step, they wanted the parties to negotiate damages. And if the creditor refused to participate at this stage, then they referred and engaged a mediator for 60 days. And last step, they said that if the mediation also fails, then they will go to arbitration. And you people will be happy to note that in that claim, half the claims were settled in the first stage itself, and most of them were settled in the second stage. So it was a first example of win-win negotiation and mediation in bankruptcy cases. Of course, in USA, they came out with Alternate Dispute Resolution Act in 1998, and in which each federal court was required to authorize ADR in all civil actions, including the adversary proceedings in bankruptcy cases. For instance, in 2004, in bankruptcy court of District of Delaware, established before certain adversary proceedings, the parties had attempted to reach an agreement in mediation. And as a result of ADR was used in 60% of reorganization cases in USA from 2000 to 2011. So it was a very encouraging, and there was a very high rate of success in USA. That is one example which we can follow in India in bankruptcy cases. When I'll be dealing later on, I'll give my suggestions regarding the Indian Act. Secondly, when we look at the mediation in Europe, like in USA, they came around for mediation through their 1998 Act, ADR Act. In Europe, European Union member states, they had not followed through legislation, but it has emerged from case law. And several European states have introduced pre-insolvency dispute resolution methods, which are primarily aimed at rescuing the debtor. For example, French insolvency law provides for two special procedures, ad hoc mandate and conciliation. In Germany, the insolvency plan procedure enables the debtors and creditors to conclude the insolvency plan by negotiation. In Italy, they have insolvency systems offer several possibilities to entrepreneurs facing financial difficulties in restructuring their debts, all of which are conducted totally or partially out of court. And they have designed three plans. One is they call recovery plan, second they call debt restructuring agreement, and lastly they call is preventive arrangement with creditors. The third plan, of course, is by and large an adjudicatory plan, but the other two are basically mediation-based plans in which the parties negotiate. And let me say in a nutshell, in European example, the procedure allows the debtors to seek the arrangements with the creditors based upon the restructuring plans certified by the professional. So it is a mix of mediation with the professional inputs that the resolution is brought about out of the court. That example can be model. That model can be adopted in India as well. So,
Mr. Khanna, I think you have in fact substantially answered the next question which I wanted to ask you. The thing is, before we proceed further, I would just like to acknowledge the presence of some of our very eminent mediators and judges. Justice B. Rajendran is here. Welcome, sir. Charlie Young, Jeremy Lack, JP Singh, Mr. Dhirendra Parekh, Jitendra Sharma, and Sheila Balsari. So, my next question is to Mr. Sriram Panchu and Mr. Rakesh Khanna. Sir, I would like Mr. Sriram Panchu to answer this first. So the Insolvency and Bankruptcy Code of 2016 has actually scripted a sort of a success story for resolving insolvency cases in India. Now, there are two outcomes that are contemplated. One is resolution, the other is liquidation. Now, data from the Insolvency and Bankruptcy Board of India shows that more than half the cases closed under the corporate insolvency resolution plan actually ended up in litigation, and only about 15% ended with a resolution plan approved. Now, this shows that somehow the system is running away from its intended purpose. Now, what is the possible impact that this can have on businesses, and what do you think needs to be done to ensure that resolutions are more and liquidations are less? Will mediation help in this regard? Mr. Sriram Panchu, sir.
Thank you, Jawad. Firstly, congratulations to KDLX and to Nivaran for hosting this program. It is such a pleasure to be here with Justice Joseph, Mr. Brian Spears, my friend from Singapore, Joel Lee, Zoe, and who have I, Rakesh, of course. Who have I left out? And Jawad, Pushya, and you. And yes, I know who left out. Rahim. Rahim, I think, is significant for India's ADR progress because he spearheads ADR, ODR. So, Rahim, a special welcome to you. A brief preliminary comment. The business resolution clause is not looked at very carefully when the agreements are signed. It's not the focus. It becomes a focus when there's a breach. But that is now starting to change because of multiple options like mediation. And the important thing here is that business needs both predictability and certainty in substantive laws and in resolution process, in respect of outcome and reasonable estimate of time. And really it's mediation which provides this. So this is a precursor answer to your question. coming to the Insolvency and Bankruptcy Code in India, I think an important question is how many cases are actually settled? And we tend to think that not many. But the IBBI reports may be more encouraging than what we think, which basically means that some settlements are taking place, but we have no structured system for organizing settlements. And that is something we need to focus on. Because the professionals, the resolution professionals under the IBC, they focus on a resolution plan, which they really, is what they're well versed in. So they find it easier to sell the company and its assets or the shareholding. It's far more difficult to find a negotiation settlement because that involves negotiations with lenders who may have to take a sizable cut. You see, here's the difference. Earlier, you had the Board of Industrial and Financial Reconstruction. But that was tasked with the health of restoring, with the task with restoring the health of companies. And that functioned like a management exercise, bringing together stakeholders, conducting negotiations, persuading parties to come to a solution. Now, unfortunately, the focus of the IBC is, more, I would say, on resolution by sale of assets. Really, I think we need to bring back some of the BIFR concepts. Because like Mr. Prabhu said, the impact of business being wound up, you deplete the value of assets, running enterprises come to a halt, workers lose employment, and the nation loses productive assets. So really the primary effort should be mediation. Now bear in mind that a single default under the IPC, a single default can take you to the IBC. A petition can be filed. And therefore, really, it is, I think, in cases where petitions are filed and perhaps at appeal litigation stage, where one should look carefully at structuring mediation processes in the IBC. And if we have clear timelines and clear processes, I think mediation will work. Right now, bear in mind the IBC makes no provision for mediation. So I think provision is made and a structure and a system is brought about. You will see good results there.
Thank you, Mr. Shriram Banchu. You have rightly said that this is the right time for us to introduce provision for mediation in our IBC code. As I was looking at the government's commitment, I found it was on 22nd April 2019, a statement came from the Government of India that they want to introduce a specific provision for mediation like they have in the Commercial Act and other acts. They want to have a specific provision where they want the parties to try mediation before they proceed for winding up. You see, ultimately, when we are talking of ease of doing business has to be looked at from both the angles, debtors as well as creditor. At times, you see the creditor, because of the circumstances beyond his reach, is unable to fulfill the commitment, and which lands him to the IBC code proceedings. You see, if we will try the mediation process, certainly this 42% success in the matters will definitely go much higher. In fact, the effort of the IBC code has to be that there is more of resolution and less of winding up of the companies. And for achieving that, I think rather than adjudicatory process, we will have to take the route of mediation. Of course, when you have given the data, you are absolutely right. If we look at the data till March 2020, 3,774 corporate debtors have been admitted to IBC process. And out of them, 1,135 have exited through resolution plan or liquidation. 221 corporate debtors have been resolved under the code, with the creditors having recovered 1,84,000 crores. And it's about 191% of the liquidation value of the corporate debtors. Now, there is no doubt that the court has performed well over the last 4 years. We have tried to improve upon the court with the experiences, like the process, earlier the time period of 375 days, 330 days has been given from 270 days earlier. But the experience shows other way. It is still taking much more time. There are large number of cases pending. When I look at the data on September 30th, 2019, there were 10,860 cases in NCLT, which were pending, and under the bank IBC code. So it will be high time that we have to go in for mediation. Of course, you see, the mediation will bring not only solution to the parties, but it will enable them to maintain their business relationship also. Now, it is like, you know, the old saying, you can't kill the gold egg-laying hen to get everything. You see, if you will wind up the company, it will not only harm the business relationship, it will also take away the earnings for the laborers, for so many people attached to the industry. So in the larger interest of the industry, without going into the blame game, I think the mediation process, which is a voluntary process, wherein these parties, that is the creditors and debtors, will evolve a resolution process, will be one of the best solution in IBC code for the parties to adopt. It is, I repeat, that it is high time for incorporating appropriate provision in the code to link there is in the formal and informal insolvency resolution process. And the experience has shown that an informal procedure that is recognized by the legislation gains more acceptance amongst the stakeholders. And amendments may be considered in the statute in order to include a healthy, inexpensive, fast practice of mediation, which insolvency process to the extent is feasible. We can even think of a hybrid process where you see partly it is monitored by the IBC, under the IBC code by the NCLT, and partly it can be done by the mediation process. Thank you.
Thank you, sir.
Thank you, sir. You have, as you suggested, I think an introduction of a mediation, maybe even a mandatory mediation process in the IBC would be a very, very welcome. Now, one more question on the IBC, that due to the pandemic, it has placed a huge challenge on the code. Section 10A has been inserted. It relaxes the rigors of Section 7, 9, and 10 of the code. The threshold for initiating insolvency proceedings against a defaulting company has been increased from 1 lakh to 1 crore, huge jump. Do you see this as an opportunity for the use of mediation to resolve disputes? Mr. Sriram Panchu.
You know, firstly, 10A is a temporary provision brought in because of COVID. And I'm not even sure it's been extended, but it's a temporary provision. So you can't expect it to be there for a long time. But I think the important thing is that the concept of 10A And what TENE gives you is a kind of a hiatus. TENE gives you the time space within to look at mediation. Time space in which to look at dispute resolution. And that is important in TENE, because don't forget, 12 gives you the opportunity, 12A gives you the opportunity to withdraw the petition. So if you link a concept like TENE and 12A, withdrawal of petition, then really you're starting to bring in the guidelines, the ground system for mediation. But you know, for mediation to really work, I think you need to look at the capacity that you build into the system. Now, the tribunal is more of a legalistic stroke bureaucratic composition, and the insolvency professionals are not mediators. The third problem is that lenders are not geared towards mediation settlements, especially their public sector units. Public sector units are major lenders, banks. Now, unless we have a system by which we can enable the bankers to enter into mediation settlements without fear of repercussions, they're going to find it difficult to take the cuts that will be necessary, either a cut or a deferred payment. So that is something really we need to look at, apart from procedure. Effectively, what do we need for resolution to move? So that, plus I would say these structural points at which we can see similar to the provision you mentioned, if that can be made a more permanent provision, 10A, coupled with a mandatory pre-institution requirement, then I think you can have something that works. So prior to institution, subject to interim orders, and during the process. Yeah.
Okay, you're muted. Hello. Yeah, sorry. Can you hear me?
Yes, I can.
Okay, thank you, sir. My next question is to Rahim and Zoe. Now, with the pandemic impacting the physical hearings before the courts, arbitral tribunals, courts, all are affected now. So digital platforms have come to play an important role. Now, when we talk of digital dispute resolution, does it merely mean using digital platforms for creating the interface between the disputants and the judges, arbitrators, or mediators? Or does it mean rethinking the entire process involved, including the system of filing cases, initiating proceedings, filing documents, and so on? So what is needed to be done to really make digital dispute resolution a comprehensive system covering all these processes and legal requirements? Rahim, would you like to go first?
Thank you, Jawad, and good afternoon to all the distinguished panel members. I'm delighted to be with all of you today, and to all the people watching in India and around the world. Good afternoon, good morning to you. Jawad, you raise a very important point. And in order for us to start thinking about having a legitimate and viable understanding of digital dispute resolution, it is a multidisciplinary, multi-stakeholder development. And what we're seeing right now, due to the pandemic, and probably pre-pandemic into the early part of the pandemic, is we have a very disparate system of dispute resolution. You know, we have the courts in one place. We have arbitrations taking place in another place. We have mediations who don't want to be involved with either or the other, so we have another third place for them. And then something that Zoe had shared with me earlier, and I'll ask her to speak about it a bit later, but the idea of really focusing on making technology the fourth party to your dispute resolution. And if you start thinking along those lines, what you need to have is a combined understanding of how dispute resolution can work for all the stakeholders in a way that gives you a total rethink. So not just the platform becoming a user-friendly experience, but as you just said, from filing cases to whether they're going to go to mediation or to arbitration or to something else, you know, how do you make that happen? And it is a multidisciplinary dimension. So my first point really here is that we need to skill up the users of these processes. And what we've got is a real lack of understanding of the potential of technology and how they can start to use these. The second stage will then be to hybridize these aspects together. And organizations like ours and many others around the world will work on creating unified platforms. But that's only one argument. What you need is everyone to step up to start understanding the potential of it, especially lawyers, especially mediators, especially arbitrators, and especially judges. And if they all start to understand the force of what this can do, then we will look back at the pandemic, of course, as a very sad time in human history because of the loss of life that we are seeing and the devastation on people's lives. But we will see it as a turning point towards peacemaking in a completely different way. So yeah, those are my thoughts.
Thank you, Rahim. Zoe, would you like to add on to what Rahim said?
Yes, thank you so much. I would only add that my observation is that as ODR is part of e-justice, and e-justice is moving very fast, thanks or due to the pandemic, my view is that what we have to consider is how we will build this, the human element in all this interaction, and how we will increase the digital empathy and all the mediation skills that we practice very completely on live mediations and not only on ODR. So in my opinion, this will be the next question. And DDRS, which is the Digital Dispute Resolution Specialist that ADR ODR International has created, I believe is the future in for all the practitioners in the dispute resolution sector.
Thank you so much, Zoe. Okay, I think unfortunately Brian Spears has to leave. So actually my next question was actually intended for him as well as Joel. So I'll ask Joel this question. Joel, you are quite familiar with India, right? Oh, Brian is here. Thank you. Brian, would you like to answer this first before Joel goes? I think you have to leave, so I just want to ask you this question. Now, are there any cultural dimensions that are at work that are, you know, sort of restricting a more widespread acceptability of mediation as a means of dispute resolution by Indian businesses? Now, how do we address these dimensions and overcome these reservations?
Yeah, thank you. And I'm afraid I do have to go, but thank you for this opportunity to reflect something on this interesting question. Like Joel, I would not pretend to advise. Every jurisdiction has their own cultural sensitivities, but as a general remark, slightly light-hearted, but with a serious core, I say that the greatest cultural impediment to making more use of mediation is lawyers. And I'm afraid that unless we get past the resistance of legal professionals to doing things the way they've always done them, we are going to simply be stuck with the same adversarial mindset and the same need to apply law that was written decades ago, but society and the world has moved on. As Zoe and our previous speaker has made very clear, in the pandemic, we have moved effortlessly to meeting like this, to having swift and immediate video facilities for speaking almost face to face. And yet our legal training does not equip us in Zoom call handling and in online advocacy. And we simply need to change and change rapidly the training of students, the challenge to the established lawyers who get the cases and have influence over clients as to how the cases are dealt with. Our courts need to be more almost interventionist to say, why are we taking up court time in dealing with this matter, which is eminently suitable to mediation? And there are lots of publications about what cases lend themselves especially well to mediation. Really, I would say the shorter list is what cases do not lend themselves to mediation. And those are really cases of urgent intervention or protection of property and persons. I find myself once again aligned to the thinking that Joel has expressed through the superb Singapore Mediation Center, which is very much a thought leader in these regards. So leaving you to your deliberations with the challenge that really the cultural problem is the legal profession. Joel, I hand you the baton to answer the question more thoroughly and with more interest than I've been able to do. And thank you for inviting me. I will listen to Joel, but then I'll have to exit with another priority. Thank you.
Thank you, Brian. Over to you.
Well, thank you, Brian. That was very kind. No pressure at all. No pressure at all. And I'm very tempted to just simply say, my lords, I concur. But I shall try to see if I add a little bit to that. I agree with Brian that that really if we want to talk about a cultural dimension, the legal mindset, the way we train lawyers, the way we think about conflicts and resolving conflicts, is an aspect of that culture. We can call it legal culture, as it were, or legal education culture, and so on. So that's one aspect. I think I'd like my answer to sort of take a slightly different spin on this, because I think we are agreed on that the mediation advocacy, for example, mediation awareness needs to be taught, and the mindset needs to be changed really at a very early stage. But I want to throw a couple of things in for the mix, and they relate actually to how we actually measure culture in the more conventional sense. By that I mean whether it's a national culture or whether it's a race culture, ethnic culture, those kinds of considerations. I draw on two aspects that were pioneered by cultural sort of scholar Gerd Hofstede. One is the notion that some cultures are actually higher in what we call power distance. In other words, they're more hierarchical. And there might actually be a tendency, I've not done research on this, so please don't take this as the gospel truth, but high PDI countries might have a tendency to want to resolve their disputes via an adjudicative process whereby someone in authority tells you what to do, right? And I think that needs to change. That needs to change in line with sort of teaching law students and lawyers to think differently. So that's one cultural dimension that I just want to highlight. The second cultural dimension I want to highlight is what we call the individualism, collectivism continuum. And one of the most high individualistic countries that we actually know about is actually the United States, and with their very strong focus on rights, right? And so actually resolution of a dispute generally is about vindication of rights. And the rights is defined as sort of individualistic. So the idea then is also a movement from saying it's just me, which is my rights, and I'm trying to vindicate it, to actually, in a sense, the greater good or the collective, whether we talk about it in terms of amicable dispute resolution or the community and so on and so forth. I think we as mediators all have certain frames that we use when we mediate. to try to bring people's sort of individual sort of rights positions down into something that is a little bit more mutual. With completely agreeing with what Brian has said, I just wanted to throw in those two cultural dimensions, sort of from a Goethe-Hofstadter perspective, just for the consideration. Thank you.
Thank you, Joel. That was very insightful. Ushia?
So, is Julian Joseph here?
Yeah, he's here.
This question is to you, sir. Now we see that mediation provisions exist in almost all new legislations, including the IBC, Companies Act, Consumer Protection Act, Real Estate Regulation Act, Micro, Small, Medium Enterprises Act. But these are either not invoked at all or invoked very rarely. There's somehow a reluctance on the part of the businesses to resolve the disputes in spite of the advantages. Like Mr. Joel Lee said, it is a cultural block, both on the part of the lawyers and also maybe from since we are a kind of a hierarchical society, wanting somebody else to give the judgment. What is the reason? What do you think are the reason? And do you think there's a lacuna in these provisions? And what is needed to be done to make mediation more popular?
Yeah, thank you, Pushya. Though I had referred to this question also in my previous observations, I also would like to add that the mindset of our regulators or tribunals or judiciary should change. They should also think that this is also an effective tool for resolution of disputes. It's not as if only the judgments can resolve a litigation. No. As our great trainer, Mr. Joel Lee, who has trained me also, I'm so glad that our guru is there. So we used to say, no, see, actually, it's a mindset. Because it is for them to decide which is this appropriate. This is a dispute appropriate enough for adjudication or for arbitration mode of resolution or for mediation mode of resolution or any. There is this fourth mode also in India. We call it Lok Adalat. One of this. So even now in the judiciary, in India, I can tell you 50% of them do not believe in this concept at all. I had no problem if you quote me once because they don't think that this is a very effective mechanism. They feel this is something substatus. That is the whole problem. Number two, of course, the mindset of the lawyers. The lawyers give, if the lawyers really think that yes, this is a good method to assist the client in the interest of the client. This is where I want this paradigm shift. The interest of the client. If they really take it, suppose you receive a Section 80 notice. This happens in states, I know. Section 80 notice. Immediately, there are two lawyers. They have a discussion over phone on the possibility of a settlement. And before the matters reach court, they discuss and involve their clients also and settle the disputes. So the mindset of the judiciary, mindset of the lawyers, and of course the mindset of the business goods, I must say the business people also, because they have a feeling that let the court take a decision. We don't want to go for a settlement. Their ego, that's a cultural aspect. Mr. Brian and Mr. Joel also have been speaking about. That also should change. It's not. What do they want? They want their business to succeed, or they want their ego to succeed. This is where they have to take account. So judiciary, lawyers, and the litigants should have a deeper examination of conscience and a fairer approach with regard to resolution of disputes and the ease of doing business.
Thank you very much, sir. Thank you. We are actually running out of time very badly. So the last question that we would like to ask would be open to any of the panelists, but specifically we would like to ask that question to Rahim Shamji, to Zoe, to Mr. Sriram Panchu and Mr. Rakesh Khanna. My only humble request is if you can keep your answers a little short, it will be very nice. Maybe we can try to answer some of the audience's questions also. Now, the last question is this. With the kind of dramatic and impactful changes that are happening actually in the field of dispute resolution, where do you think the legal profession is headed? Do you think that the time has come for lawyers and law firms to actually reimagine their roles, let go of the old paradigms and embrace the new realities that are emerging? Shall we start with Rahim?
Jawad, thank you for that. It's that's quite a difficult question, but an interesting one. And if I come across as being a bit blunt, to keep brief, then forgive me. Yes is the short answer. The time has not just come; it is past. And I'll give you a very short example. I've been practicing law for 20 years now. When I was applying in the UK to barristers' chambers, if I'd have told those barristers' chambers that I wanted to be a mediator in 2000, they would have laughed me out of, forgetting getting an interview. Now barristers' chambers have mediation suites, they have dispute resolution departments. Some of the biggest law firms, the Magic Serpent as we call them in the UK, I work for one of them. They used to have a litigation department. But if you call them now, it's gone. It's called a dispute resolution department. You need to be able to understand the diversity and the plurality of resolving disputes effectively. And what we've been trying to do in India for the last 6-7 years, Jawad, as you will know, is to really focus on the next generation of peacemakers. It's the students, the graduate market, to really say to them, do you have the tools to deal with tomorrow's disputes? And if we can do that, then generationally, we will see huge impact in that development. I could talk for longer, but I'll stop there.
Thanks, Rahim. Mr. Sriram Panchu.
You know, it's not an easy thing to ask lawyers to let go of anything. But I think the focus should really be, well, have a wider embrace. Here are new professional opportunities opening up. And I think there is no shortage now of law firms who are coming to see that. I would say two things will propel this tremendously. One is pre-litigation. The other is online. I think online is going to make a big difference in mediation because it is the most friendly aspect as far as consensual discussion-based dispute resolution is concerned. And I think there's nobody better here than Rahim to tell us about this because he's done it worldwide. So I think there's not much doubt about it, that where the legal profession is headed. The legal profession is clearly headed to opening up. And it's a question of, in time, I think one will see much of commercial and personal and property litigation getting off the courts, arbitrations getting more specialized for certain kind of disputes or, existing incompatibility with mediation. And I think you will see mediation assuming quite an important role.
Thank you, sir. Zoe, what's your take on this?
Thank you. I will try to address my short answer to your students, Jawad, who are the next generation of peacemakers, as you mentioned. In my humble opinion and from my experience, the legal background is super important. And I wouldn't advise the new lawyers to focus only on ADR. I think ADR is a toolkit in their toolbox. Being lawyers will give them huge credibility. This is the reality worldwide, and also will help them a lot as we mediate in the shadow of the law. So in my humble opinion, they should combine all this experience and expertise in order to be competent for the present and for the future. Thank you very much.
So, Zoe, what do you think, Mr. Rakesh Khanna?
Yes, it is a very difficult question, but you see, whenever we start with a new system, with a new thinking, the new process, there have been apprehensions. When we started with arbitration, there were a lot of apprehensions in the minds of the lawyers. But today, arbitration in itself has become an expertise. And many lawyers, especially new generation lawyers, are getting expertise only in arbitration. I have no doubt in my mind that in times to come, mediation in itself will also become a very, very specialized field. And especially when we are talking of pre-litigation mediation, we are trying to reinforce the faith of a common litigant into the judicial system and into the resolution of dispute system rather than a fighting system, fighting spirit. And I believe, in my honest belief, in times to come, mediation will be a path to follow. Like in many countries, it is mandatory before you go for a civil litigation, you have to undergo the process of mediation. And that process has helped in resolution of the disputes before litigation and during litigation. So that I think there is when you are saying that the lawyers will have to change their mindset, yes, definitely. And I think it will be for the good of the lawyers.
Thank you, sir. Joel, would you like to say something on this?
Again, I can say, my lords, I concur. I actually agree with a lot that has been said. Maybe I'll just add one thing. And I think it's sometimes getting the lawyers or the law students to understand that that they are more than just litigation, right? They are there to solve the client's problem, and they have a number of ways of solving the client's problem. It's just that right now all they think about is litigation is the only way to solve a client. So they're in opposition to what mediation is. Mediation is opposite to litigation. It's an alarming drop in revenue, which is what ADR, they think ADR is. So therefore, they'll push back against that. But as Mr. Panchu has said, it is a tremendous, it's a possible business opportunity. There's a line of revenue, and not just as mediators, but mediation advocates, because you will still need lawyers to protect the clients, to ensure that the process is balanced and so on and so forth. So the thinking has to be expanded to encompass these things. It's kind of the point I just want to make. Thank you.
Thank you, Joel. I think we'll have the last word from Justice Julian Joseph, and then we'll open the floor for any questions.
I think it's fairly discussed. We'll leave it to the floor if that they have to ask anything.
Okay, sir. Thank you. So basically what all the panelists seem to agree upon is that the future lawyers should not be problem inflamers. They should be problem solvers. Thank you. So any questions?
It's really additional areas of practice.
Exactly. So any questions from the audience, please? I know it's very late. We are very sorry about that.
Yes.
Because the topic has been so engaging and interesting that, and the panel has been such a great panel that, you know, we just couldn't stop listening to the insights from such learned people. So any questions, please? I don't know whether in the chat some questions have come. Let me see, unless if somebody has a question, you can please unmute yourself and ask the question. Some very interesting comments have come.
Chitra Narayan wants some answers, questions.
Yes, Chitra, please go ahead. Chitra, please go ahead. 1 minute, Chitra. Yeah, can you unmute yourself, please?
I think, thank you for a wonderful discussion. Companies, I think, are best placed, since the context of the discussion today is ease of doing business, companies are best placed to actually utilize mediation because they have the resources. They get the advice from their advisors on what is the best way of resolving disputes that arise. And for them, time is money, and they ought to be focused on doing business rather than dealing with disputes. What would you suggest are the ways in which we can engage with companies, as mediators, to encourage them to use mediation? This question is for any of the panelists. I mean, intuitively, they should be using it, but...
who would like to take this question?
Can I ask this question of Rahim?
Rahim? I think Rahim had to leave, I suppose. I don't see him here on the screen.
Is that?
Yeah. Rahim is here still. Rahim, are you there? I just saw him.
Quick comments.
Yes, sir, please.
Industry associations, success stories, presence of professional mediators. 3 suggestions.
Thank you, sir. Any of the other panelists would like to add something?
Yeah, Javed, can I say something?
Yeah.
Yeah. I wanted to comment on the cultural side when that discussion came up on the cultural side of it. I personally feel India has got a massive potential for international arbitration. And I think the next generation of lawyers, the young ones, who are in law school now or who are working as an intern, I believe they should be prepared or they should be trained to work for international mediation and international arbitration. There's so much potential here. India is the center of the world when it comes to business, whether it is commercial or defense. And if we have lawyers who can understand the culture, and this is the part that I wanted to cover because I do a lot of cultural side of mediation here. Culture is not just about ethnicity. It's not about Indian or Caucasian or an African. It is your own culture. It's your own belief, your own ethics. So the introspection starts. Okay, what is my culture in business? Am I here to help someone, or am I here just to make my money? So it starts from there, and then understanding the culture of the parties. What are their individual values? What is the term of business that they're doing together? What has been the culture of business within them to understand that? And then it comes to ethnicity. Then it comes to cross-culture, cross international. Like if you do business with somebody in UK, their style of business is different. You try to do business with someone in Australia, the style of is business. So the local knowledge helps. But I personally feel that India has got so much potential to offer to rest of the world when it comes to international arbitration. I feel the Indian system for arbitration is still very in an infant state. But if you can use the lawyers and the experience, like the panel here today, it's amazing the experience, I'm just listening to. If you use that experience, but you use the arbitration rule and the arbitration seat of another country, which is more transparent, you're bringing 2 best worlds together. And this is my suggestion. India must look at international arbitration as a business. That's how I say it.
Thank you very much, Jagdeep. Jagdeep is from Australia. Am I right, Jagdeep? You're from Australia, right? Thank you so much for joining us today.
Yes, correct. Originally from India, but yes.
Yeah, thank you. Zoe, I see your hand up.
Yes, I would like to address to Mrs. Narayan regarding her question. I would add that a best practice would be to add mediation, arbitration, ADR clauses in the agreements that the companies have with other companies. So that would be a start to promote mediation and arbitration. And what we do here in Greece, because we are at an infant stage as well, is to have an escalation of ADR disputes in our contracts. I mean commercial contracts, business contracts. And this is a way of promoting ADR in a gentle, supple way in businesses.
Thank you, Zoe. I see one hand, Mr.
Somebody's
Parameswaran.
raising his hand.
Yeah, Mr. Parameswaran's hand is up. Mr. Parameswaran, what is your question, please? Mr. Parameswaran? Okay, we are not able to get. Yes, Gunasilan, Guna, you have any question, please? Gunasilan is also a renowned mediator. Yeah, you're muted, Gunasilan.
Yeah.
No, please unmute yourself. Please unmute yourself.
Yeah.
Again muted.
Okay. Okay, am I audible?
Yes, yes.
Okay. Now I would like to ask this to Sriram Panchu, since he had been the person who was from the beginning. In fact, in Madras High Court, he was the one who was instrumental in bringing about the court mediation process actually. Now, with the advent and with the development of international trade and commerce, and with the multiplication of commercial litigation going all around, also with the Commercial Courts Act bringing in pre-mediation litigation, don't you think, Sriram, it's time that the mediation process as such should be inclusive of much more specialized agencies who are already there in the field, like very many institutions are there. But what happens is when the matter is referred to court annex mediations, it comes under the ambit of National Legal Services Authority and State Legal Services Authority. Don't you think that it must be eased off in such a manner that these institutions with specialized expertise in their hands also to be brought within the ambit, so that more of this ease of doing business and international trade and commercial arbitration, commercial mediation can be more accentuated by this process?
I agree with you. I think basically reference to mediation should in the first place be to mediators selected by parties.
That's right.
Parties select institutions or mediators. That should be the first. Second, I think the court should have a roster of institutions and mediators. The court should maintain a roster. I think only the parties do not select from these that you then think of sending it to an authority. And I think even for these, you should work out some system where the mediators, the institutions both charge a professional fee as well as also render pro bono service in the appropriate case.
Thank you, sir. I just want to read out one message that has come on chat from Kainath Pandu from Jindal Global Law School. She's a student of Jindal Global Law School. She says, I think as a final year law student, I can testify for the change that we can expect in the coming generation of lawyers. Since I was introduced to mediation via ADR ODR International 5 years ago, I have been pursuing mediation and negotiation training alongside my legal studies. I'm just one example who has further engaged with students in my college. This is common across law colleges in India at present. Hence, I have full faith in upcoming lawyers favoring consensual settlement to litigation and adversarial issue processes. I think that's a very encouraging comment coming from one of the future.
Very encouraging.
Yes. So thanks a lot. I see two more hands up. Mr. Venkat Raju. Mr. Venkat Raju, can you unmute yourself, sir? Can you unmute yourself, please?
Yes, yes.
Yeah.
We are from Hyderabad, sir. My question to Sriram Panchu, sir. That is regarding, in spite of having a lot of training in mediation center, 40 hours training, the matters cases are not referring a lot. Is there any suggestions from your end, sir? That is a small question from us. Sir.
If we are talking about referral by the courts, I think the suggestion is twofold. To one, work with the judges. The second, with the, as I said, for more widespread reference. And the second is to see why, you know, are you, how many years at the bar are you?
We are from 25 years, sir.
So
25 years.
why are cases not being referred? Obviously, because not enough cases are there.
No, so many. The Indian sees lot of lakhs of cases in Telangana High Court in Hyderabad. But we are trained, so many persons are trained. Even mediation center also very developed.
It's a question of, you know, increasing the number of referrals of
Cases.
cases and pending cases.
Courts are not referring.
Yeah, and for that, I think, you know, it's the local chief justice who has to be approached.
Obliged. Thank you, sir.
Thank you. I see one more hand, Mr. Deepak Prakash. Mr. Deepak Prakash.
Hi, I'm Deepak Prakash here. Just my question, scope of ADR in the cross-border transactions. Example, just given an example of this DHFL case we may know. They're saying that more than 40,000 crores, they are taken from India and some other countries. This accepting. The owners of the company is accepting. What is the scope of so many international people are here, especially this Kurian sir also is here. Just what is scope of the ADR in cross-border frauds and other things? Admittedly, money is outside India.
So who would like to take the question? This is Julian Joseph.
Yeah, Deepak, thank you for the question. Say, all of us know if it is cross-border or it's international, or otherwise also there is scope provided. You know, I would only say from this word stakeholder, this attitude should change to duty holder. If you all become duty holders in dispute resolution and aiming at easing our business and purchasing peace, things will improve. Makes no difference whether it is cross-border or domestic. Thank you.
Thank you, sir. Thank you.
Thank you. Are there any other questions? Kavita, I think you asked some question on the chat. What about RERA? Can you elaborate on the question, Kavita?
Yes. Good evening, everybody. Thanks for the opportunity, sir. My question is that real estate and real estate development is an important sector wherein huge amount of money is being held. And finally, the only thing is RERA, which is being taken up, all the issues have been done. But there has not been any progress or any mediation so far in RERA. There are a lot of issues that can be resolved through mediation in fields like real estate and development authority and consumer problems with respect to the real estates. How do we address this issue? Why this field has not given much focus? Can somebody tell us that?
Javed, I think Justice Rajendran is there. He's the appellate authority now. He's the best person to respond to it.
Yes, exactly. That is exactly what I was thinking, sir. And I also see his hand up. So.
Very good evening to all of you, my lord. Julian Joseph, nice to see you all here after a long time. Well, this question regarding mediation in real estate is already started, especially in Madras. We have referred 3 cases already to the High Court itself. High Court referred mediation itself, and 2 cases we referred. 1 case, of course, I personally mediated in the open court, a company which has already been closed, which is not doing. In that particular case, a compromise was arrived, settled. They gave the villa, because that was only 1 case, a villa. In 2 other matters, where 19 flats, they agreed and made an endorsement within a particular time to be given. So in Madras Appellate Tribunal, as well as in the Real Estate Authority, we have been referring. We have already started it. Of course, both the cases which has been referred to the mediation center to the Madras High Court, 1 case partially ended, but later on when it came back to us, we made them, you can understand, we made them to settle. So things are already moving. Madam Kavita Balakrishnan should be very aware that we have already started it. It will be done in a much better way. But the only problem is it is a long pending matter. When they can't, they say, if I accept for one person, I'll have to accept for hundreds of persons. So they are not willing to come. Though, therefore, we have to restrict to a situation where it's a limited one. That is the only problem for the builders. So we have been effecting and we have started. This definitely mediation is the best way. We are projecting it and we will do it. Thank you, Jawad and everyone, Mr. Sriram Panchu, to see all of you here today.
Thank you, sir. Thank you for joining us today. I think we have almost, we have way crossed our time, long time back. It's almost 7:10 now.
We exceeded the time.
Yeah, we have far exceeded the time. So may I, Mr. Jitendra Sharma is here. Mr. Jitendra Sharma. Okay. Usha, can you please deliver a vote of thanks on behalf of all of us, the organizers?
Yes, on behalf of the organizers, I thank Jawad first for giving me an opportunity to be a co-moderator with him. And it has been an extremely exciting panel, and everyone has spoken so well and there's really been a brainstorming session rather than a webinar. And I think the audience also has been very participative and very pleased with it. I thank everyone. I'm not thanking everyone by name. 1 minute. I don't want to leave anyone out. Thank you, Justice Rajendran, for coming and for also giving us the good news that Vera was also into mediation now. And Justice Julian Joseph, thank you for chairing this program and doing such an excellent job. And we have had international faculty here, Mr. Joel Lee, Mr. Brian Spears, Rahim and Zoe, and we've also had a former Union Minister, Mr. Suresh Prabhu, and of course our father of mediation, Mr. Sriram Panchu, and Mr. Rakesh Khanna from Nivaran. Thank you all so much for making this such an exciting event. And we've had an extremely good turnout of audience, so I thank the audience also. Thank you.
Thank you so much. Thank you.
Thank you, everyone. Thank you so much.
Thank you, everyone. Very nice. Thank you.
Thank you, sir. Thank you. Thank you, Joel. Thank you, Zoe.